Force majeure is much in news as coronavirus outbreak has affected obligations and its performance or performances by parties to hundreds of commercial contracts. There is a queue up to invoke and take shelter or recourse to this common clause in contract known as force majeure that essentially frees both parties from liability or obligation when an extraordinary event or circumstances beyond the control of the parties, such as a war, strike, riot, crime, or an event described by the legal term act of God, like hurricane, flood, earthquake, volcanic eruption, etc., prevents one or both the parties from fulfilling their obligations under the contract. In practice, most force majeure clauses do not excuse a party's non-performance entirely, but only suspend it for the duration of the force majeure. Force majeure is generally intended to include occurrences beyond the reasonable control of a party, and therefore would not cover, for example, any result of the negligence or malfeasance of a party, which has a materially adverse effect on the ability of such party to perform its obligations. Secondly, for example, it may not include any result of the usual and natural consequences of external forces. To illuminate this distinction, take the example of an outdoor public event abruptly called off. If the cause for cancellation is, ordinary, predictable rain, for instance, this is most probably not force majeure. If the cause is a flash flood that damages the, let's say, venue or makes the event hazardous to attend, then this almost certainly is force majeure. Other than where the venue was on a known flood plain or let's say the area of the venue was known to be subject to torrential rain, for instance, then obviously it would be treated as it would not be treated as a cause of force majeure. Some causes might be arguable borderline cases. For instance, if unusually heavy rain occurred, rendering the event significantly more difficult but not impossible to safely hold or attend. These must be assessed in light of the set of circumstances. Any circumstances that are specifically contemplated, included, in the contract. For example, if the contract for the outdoor event specifically permits or requires cancellation in the event of rain. Under international law, it refers to an irresistible force or unforeseen event beyond the control of a state, making it materially impossible to fulfill an international obligation, and is related to the concept of state of emergency. English common law does not automatically apply force majeure principles to contracts. It does not. Parties to English law contract who wish to have force majeure relief must spell out what constitutes force majeure in the contract itself. That's the requirement of English common law. Failure to do so means that a supervening event which prevents performance of the contract will not and cannot be caught as a force majeure event so as to provide relief from the performance, because it has not been named as a qualifying event in the contract. So you have to specify clearly what are the force majeure events. Common law recognizes the concept of frustration of purpose, a narrower concept that applies when the actual performance of the contract is radically different from what the parties intended. When a force majeure has not been provided for in the contract, or the relevant event does not fall within the scope of the force majeure clause, and a supervening event prevents performance, it will be a breach of contract. Yes, it will be a breach of contract. The law of frustration will be the sole remaining course available to the party in default to end the contract. If the failure to perform the contract deprives the innocent party or substantially the whole benefit of the contract, it will be a repudiatory breach, entitling the innocent party to terminate the contract and claim damages for that repudiatory breach. As interpreted by English courts, the phrase force majeure has a major extensive meaning than act of God or vis majeure. Judges have agreed that strikes and breakdown of machinery, which though normally not included in force majeure, and however, in the case of machinery breakdown, negligent lack of maintenance, it may negate claims of force majeure, as maintenance or its lack is within the owner's sphere of control. The term cannot, however, be extended to cover bad weather, soccer matches, football matches, or a funeral. The English case of Matsokis versus Priestman and Company held that there are the usual incidents interrupting work, and the defendants, in making their contract, no doubt took them into account. The words force majeure are not words which we generally find in an English contract. They are taken from the Code Napoleon, and they were inserted by this Romanian gentleman or by his advisors, who were no doubt familiar with their use on the continent. In Hackney Borough Council versus Dor, it was held the expression means some physical or material restraint and does not include a reasonable fear or apprehension of such a restraint. In Dharan Rajmal Gobindram versus Shamji Kalidas, the Supreme Court of India held an analysis of ruling on the subject shows that reference to the expression is made where the intention is to save the defaulting party from the consequences of anything over which he had no control. So, like they were beyond the control of the defaulting party. Even if a force majeure clause covers the relevant supervening event, the party unable to perform will not have the benefit of the clause, where performance merely become more difficult, more expensive, and or less profitable. So that is all for today in terms of force majeure clause.